a very quick introduction from me. My name is Sarah Bolt. I'm a senior associate at Irwin Mitchell. I'm also a council member for Bristol Law Society, who are very kindly hosting us this morning. And I work in the Bristol Office of Irwin Mitchell. I'm joined today by Harry Samuels, who is a barrister at 24 Old Buildings. And together we will hopefully be working through the knotty issues of what happens when private client disputes explode. This is the first of the webinars we are doing with Bristol Law Society, focusing specifically on private client. There are several others arranged for later in the year, and details of those will be circulated shortly. If anyone is interested in presenting in the future or has any topics that they want us to have a look at, please let me know. My contact information is on the last slide. A few housekeeping things before we get started today. This webinar is being recorded. The recording will be available and circulated after the webinar finishes. If there are any questions, there's a Q&A box, so please feel free to put them in. We won't look at those until the end. And if there are any questions after the event, Harry and I have got our contact information on the last slide. So taking it from there, I will hand over to Harry, who is starting our talk off today looking at harassment, defamation and injunction relief.
Thanks, Sarah. I want to start off with a sad and tragic story, and that is the story of Pattinson and Winsor. Now, these are proceedings which, as the title of this presentation suggested, began in the Chancery Division and began life as a probate claim. So what I want to do is I want to set out briefly what the probate claim was all about. Then I want to talk about what happened after judgment. And then I want to talk about the result of what happened after judgment and why it's relevant to talking about media law issues such as harassment by publication and media law injunctions. I think this is a great case for illustrating exactly what can happen in bitterly contested probate disputes and why practitioners need to be ready to be able to use non-private client type remedies and non-private client type proceedings to be able to uphold their clients' rights. So Pattinson and Winsor is on its face a straightforward probate claim. Mr. and Mrs. Pattinson were the executors of Mrs. Pattinson's late mother's estate. The will left the estate of the deceased 50% to the daughter and 50% to her son, Mr. Winsor, save for a few carve-outs for a life interest in the property for the son and a selection of various chattels for the daughter. So far, so straightforward. The problem was that the defendant brother was convinced that Mr. and Mrs. Pattinson had in fact procured the will by undue influence as a means to, and stand fast that this will be explained further in due course, but as a means to launder £130,000 of money, which the defendant brother said should have been due to him. And I've got to go a little bit into the background at that point. The defendant brother had been made bankrupt about 10 years ago, and the £130,000 in question was money that the defendant said was money owing to him as surplus out of that bankruptcy. In fact, what had happened as it emerged was that the trustee in bankruptcy had settled that with the defendant's mother, the deceased, on the basis that the mother had bought the defendant's property for him, and so therefore she, as the purchaser, had a continuing beneficial interest in that property, such as to take it outside of the bankruptcy estate. So we've immediately got an issue where this straightforward will is complicated by this disputed £130,000 in the estate, and the defendant brother says sister and brother-in-law have used the will writing process to essentially defraud him out of that money. So a claim is brought by the executors to propound the will. The brother defends and counterclaims on the basis of undue influence and fraudulent calumny, and we launch straight into a trial, and you can see the neutral citation number that I've put on the slide. Short point is Master Pester upholds the will, holds that there is no evidence at all of undue influence or fraudulent calumny. There were extremely detailed attendance notes taken, demonstrating that the will was in fact the last will of the deceased, and the counterclaim is dismissed with a fairly hefty order for indemnity costs. So in most cases, that would be the end of it. The parties have tried their issues and there is the answer. In Mr. Windsor's case, that was not the end of matters. He began to embark upon a campaign of sending emails to the line managers and colleagues of Mr. Pattinson, so his brother-in-law, repeating his allegations of money laundering, of fraud, of unlawful means conspiracy, of abuse of position, and so on and so forth. And these emails just kept coming. So the Chancery Division trial was in November of last year. Come February of this year, there are about a dozen to 24 examples of emails being sent to the employers and line managers of Mr. Pattinson. Now, what happens thereafter is Mr. Pattinson is obviously dissatisfied with this. His reputation is being traduced, but more than that, he is being embarrassed in front of his peers. So this is not a claim for reputation, because the defendant is clearly someone who believes in a conspiracy theory which has no basis in fact. So it's not vindicating what others might believe about him on the defendant's case. It's actually trying to stop him from harassing him, stop the embarrassment, the distress that is caused by these emails being sent to his colleagues. So a claim is brought for harassment under the Protection from Harassment Act 1997. So this is where we start to branch out from the traditional territory of the private client lawyer and into the uncharted territory of media law. And it's that I want to focus on a little bit now, in what are the ingredients of harassment, how do you get an injunction to prevent harassment by publication, and what is it that you may have to contend with when you go before the judge in doing so. Well, first of all, let's have a think about what harassment under the Protection from Harassment Act 1997 actually means. So Section 1 prohibits a course of conduct which amounts to harassment of another in circumstances where the person alleged to do the harassing knows or ought to know that it does amount to harassment. So immediately we've got a few problems. Firstly, it must be a course of conduct. Secondly, it has to be harassment. And thirdly, the defendant has to either positively know or the defendant ought to know that the conduct amounts to that. So course of conduct is straightforward. It means more than one occasion. Harassment is helpfully not defined in the Protection from Harassment Act 1997, but there are various authorities which talk about distress, which talk about embarrassment. It's anything of that character that is of a sufficient seriousness as to be prohibited by the law. So mere annoyance is not sufficient. What you need is actionable distress, actionable embarrassment. And then knows or ought to know. One is obviously a conscious standard. The other is a more objective standard. Ought to know that this was harassment. The Protection from Harassment Act also contains a number of defences. In my case of Pattinson and Winsor, the defence that the defendant, I think, was looking to rely upon, although he never took legal advice and unfortunately never really articulated this in a particularly coherent way, was that he was saying that what he was doing was acting to prevent fraud. He truly believed that his trustee in bankruptcy had defrauded him out of £130,000, and that a whole litany of people, including the Court of Appeal, Masters of the Chancery Division, the police, and my client, Mr. Pattinson, had engaged in a conspiracy to defraud him out of that money. So Mr. Winsor would say, and this was a point that I had to raise on the ex parte without notice hearing because of the duty of full and frank disclosure, he would try and say that this was to do with the prevention of crime, which is a defence to the Protection from Harassment Act. But fortunately, there is Supreme Court authority on what you have to show to demonstrate prevention of crime. This is the case of Hayes and Willoughby. And in that case, it is said that there is obviously a subjective element. The person must subjectively believe that they're acting in the prevention of crime. But there must also be an objective requirement. It must objectively be merited, that there is some crime or some action to prevent crime taking place. So you can't just have conspiracy theorists rock up, say, I'm immune from any action from harassment just because I reckon for no reason at all that there is a crime going on. There has to be some element of objectivity there. So that's the shape of the Protection from Harassment Act. Those are the things you have to know and show, and the things that you have to be able to, the defences you have to be able to meet. But the first step is always going to be seeking an injunction to prevent these publications from continuing. The traditional test for obtaining an injunction is, of course, contained in American cyanamid, with which all of us will be aware. Is there a serious issue to be tried? Generally, where does the balance of convenience fall? Are damages an adequate remedy? These familiar tests that we as lawyers will have looked over time and time again. But as soon as you're in the territory of publication and media, the test becomes much higher. That's as a result of two principles. The first is Section 12 of the Human Rights Act 1998 and the implementation of the European Convention on Human Rights. Obviously, being prevented from publishing materials is an interference with a person's Article 10 rights to freedom of expression. And so the Human Rights Act says that where you are seeking to restrict that right by an injunction, you have to meet the higher test under Section 12. And that test has also been explored in House of Lords Authority, in Cream Holdings and Banerjee. And the result of that test is that you have to show that you would be more likely than not to succeed. So it's not just that you've got a serious question to be tried, which is a low bar. At this stage, you have to demonstrate that you are more likely than not to succeed. So there's the first principle. The second principle is I hesitate to say niche, because this is bread and butter for a defamation lawyer, but for us private client practitioners, the case of Bonnard and Perryman and the doctrine against prior restraint is a new concept, and one that all lawyers who go down this path have to be aware of. And this rule basically says that in a libel or defamation claim, you cannot get an injunction restraining the defamation. The reason for that is some reason of principle, which is that your remedy for defamation is damages, and it's going too far to restrict the speech at an interim level. But in our case, obviously, we're talking about harassment. But harassment by publication and defamation is a bit of a continuum, and you can see that the two areas might overlap. So there is good authority saying that you have to look actually at what the nub of the claim is. What interests are you seeking to vindicate? If you're seeking to vindicate reputation, then an injunction is going to be unavailable because of the rule against prior restraint. If, however, what you're trying to do is vindicate embarrassment, distress, personal feeling, then actually harassment is probably the nub of your claim and you can proceed. So marrying all of that up, you can see I've put the citation of the interim injunction application in Pattinson and Winsor at the bottom. In this case, Mrs. Justice Steyn granted the interim injunction in my client's favour. First of all, she said that we were more likely than not to succeed. The emails were obviously of a character that would distress my client. And in fact, there were some emails in which the defendant expressly said that he acknowledged that these would be embarrassing and distressing to my client, and that that was his purpose in sending them. So the distress element was really clearly established on the evidence. Secondly, although there were elements of reputation at stake, this was not a claim where the primary purpose of the proceedings were to vindicate the reputational side of it. Mrs. Justice Steyn said that it was clear on the facts that in fact what Mr. Pattinson was trying to vindicate was his embarrassment, was his distress at the conduct of the defendant. As such, the doctrine of prior restraint had no application. Therefore, an injunction could, in principle, be granted. So, putting all of that together, there was a prima facie case of harassment. It was more likely than not to succeed. This was not prior restraint. And then the remaining factors in the American cyanamid test were met. The balance of convenience militated in my client's favour. Damages would not be an adequate remedy for this type of deeply personal distress. And in fact, on our case, the defendant was stopped from asserting that his allegations were true because those allegations had already been dismissed in the Chancery Division. So interim injunction granted ex parte. It was continued by the judge on the 16th of February of this year. And I will return to the later stages of this particular puzzle, with which, in fact, I've been dealing over the past few days when I talk about criminal remedies in due course. But that's an introduction to harassment, defamation, and injunctive relief, and an example of how they can apply to probate proceedings in the Chancery Division and be usefully used to vindicate client rights. Over to you, Sarah.
Thanks, Harry. One question I have just off the bat. First instance in the probate claim, was Mr. Winsor represented by lawyers, or did he choose to act as a litigant in person all the way through?
So Mr. Winsor chose to act as a litigant in person all the way through. In fact, there was a strange situation where he never put in a formal defence and counterclaim. In the interest of generosity and being fair to a litigant in person, my clients agreed to accept his the judge actually characterised them as rambling, so I can say that his rambling documents as his defence and counterclaim, and we distilled basically what the nub of his complaints were. But there was an interesting part of this, which is that in fact he didn't attend the trial at all, having complained that he wouldn't be able to make it, but having provided no evidence for that. The master refused his application to adjourn, and he ended up not attending at all. Now, I still had to prove my case because a will propounding claim is, of course, a claim against all the world. So I had to put all of the evidence in just as if he had been there himself. And in fact, in his absence, although I wasn't strictly under a duty to give full and frank disclosure, I nonetheless felt ethically obliged to put what the defendant himself might have said if he was there. But it was a strange set of facts.
Okay, so that leads me on to social media, which ties quite nicely in to some level at defamation and how we're dealing with things. So social media is very much changing the way that many of us live our lives, and it's seeping into the way we operate as individuals and how business operates as well. So we've got Facebook, Twitter, Instagram, TikTok, Snapchat, LinkedIn, WhatsApp. Some of them I can use, some of them can't. However, when we look at social media, it's so very clear that it's now having an increasing role in the way that we litigate if we need to, and how the courts are approaching it. So a really good example, although it's not here in England and Wales, is the one on screen, which is about a French pop star called Johnny Hallyday. And I'll send the slides afterwards, but he died in 2017, and he had made a will where he had lived, or his wife, his fourth one, had said he'd lived in California. And that primarily provided for his fourth wife and cut out two of his children from his previous relationship. Now, in that case, Instagram featured quite heavily because the law in France is that forced heirship would apply, in which case the two children would inherit under those laws. And what they did was they actually showed the amount of time that he and his fourth wife had spent in France in the years leading up to his death, which largely turned out to be more than half the year in 2015, running up to 2017 when he passed. And at first instance, in a California court, it effectively was using Instagram features in order to show that that was, and it's public available data, that he effectively was deemed domicile in France, which had big consequences for his estate. So we're looking at the various issues which social media is now coming into play, and how I suppose litigants primarily are using it and how it can feature. From a data protection view, very quickly, GDPR has no bearing on individuals using social media. So you're purely, because it's purely for personal reasons, but where you do handle data or a company is looking to do so, it must be dealt with in accordance with data protection law. And that includes how you use it for professional capacity and the processing of it. One of the key things just to highlight is that if someone is sending messages on a forum like Facebook or Instagram, that is also subject to the terms and conditions of that platform provider. So if you want to try practically to stop someone from doing something and you understand that they may be breaching the terms and conditions, a way to do that might be to report them directly to the platform provider. If you're having an issue outside of that, it may be that it strays into, as Harry's talked about in the Pattinson and Winsor case, the elements of defamation. So defamation, we're seeing social media come up more and more. I think one of the big cases from last year, the Agatha Christie case, came directly on point. So if we look at matters on social media, we're looking at essentially understanding that even if you post to your friends, that is not something that we would say is a private matter. You should always assume that effectively, if you're posting in an arena online, that even if in the heat of the moment can actually become a public issue, which you can then use in litigation and can be shared. People do screenshots, and I think it's very evident when we come on to disclosure that it can be incredibly damaging if you are then using information and pictures or statements made on social media, because it can make or break cases. So there's 3 cases on defamation on screen, and very briefly, in terms of social media, it's very much considered to be a form of communication, which can be covered by either, well, in this case, because it's published, it would be a written defamation, so libel, but you can also look at slander as falling into that. And I think the key requirement in terms of defamation changed in 2013. So you've got the statement must cause or is likely to cause serious harm to the reputation of the person. And where that party is being defamed is a company, it must also show serious financial loss. I'm going to skip over those, but share the case names and the comments I've got on my slides when we go round. But the key point for litigation, I think, primarily here is disclosure. So social media very much is becoming an instrumental tool in litigation. The contents of an opposing party's social media posts can very much make or break a case, and it can have devastating effects, particularly if you look at credibility. So I've seen in some other areas like personal injury, if someone is alleging that they can't walk, that their case is entirely broken down by social media showing that they're at a party. In our area of work, it may help to show in terms of inheritance whether or not someone actually has a close relationship or has touch points with their mum, dad, if they have that on social media. So disclosure does cover electronic documents. It does include and extend to social media. And the duty of disclosure and the preservation of that is also extended to disclosure. So a lot of people think that they can just delete posts, but doing that, I would say and emphasize, do so at your peril. Nothing ever truly disappears, and deleting a post is only likely to make matters worse, and it can, in some cases, impact on credibility. In the case last year of Rebecca Vardy, I mean, her attempts to say her phone fell into the sea were effectively held against her quite heavily when it came to disclosure, because the adverse consequence in that case was effectively that there was something to hide. So there is a legal obligation to protect evidence. You are required when it comes to the stage of disclosure to make sure that relevant documentation is disclosed, and that can extend to social media. So it is really important because it can make or break. And I've added in the harassment and nuisance element via social media. In terms of other things to look out for, there is the Malicious Communications Act 1988, there's a Communications Act 2003, and the Computer Misuse Act, which is from 1990, and I think they're on the slides for criminal matters. So that's social media in a bit of a kind of whistle-stop tour. Abusive process, and I'm sure we've all got people in mind when we look at litigants that we'd rather not deal with, or becoming vexatious or possibly vexatious. So I think the first thing to look at is what is abuse. And thankfully, again, it's been given quite a wide berth in terms of definition. There's not one kind of fitted definition. And the court generally looks at the party's conduct. And some examples of abusing the court's process could generally be abuse in the pre-action protocol. So going through it, like looking at abuse in issuing speculative proceedings, abuse where a claim is deliberately undervalued or deliberately overvalued. And it's also important to also consider whether or not the actions, obligations as us as legal professionals, because if we make allegations without merit, or we may be reckless as to the merits of a claim, or we make threats to public, like to reveal embarrassing information, we need to make sure that we are complying with the obligations that we have with the SRA Code of Conduct. And threatening and all these other things I often see happening on the other side. And a lot of the time when we have claims for reasonable financial provision, I do wonder, when it's particularly from, say, an adult child, whether or not the merits add up, or if there is something happening from a legal professional standard. So looking at coming on to the litigants option, we have the court's use of inherent jurisdiction to regulate the conduct of litigation and protect its process against abuse. We're looking at this being distinguished from the exercise of judicial discretion. It's part of civil and criminal procedural law, and it's invoked in relation to the process of litigation. So it's a summary process, not one that's done at trial, and it may be invoked not only by the parties, but by the court of its own volition. Now, that isn't an unlimited power. The court has checks and balances, and it can't go against a rule or a practice direction or an order that's already been made. But we're largely looking at the provisions that are set out in CPR 3.1, where we've got the general case management powers, and that includes staying proceedings, excluding issues from consideration, dismissing or giving judgment, or a whole range of options. But it just means that the court has that right to check in if it needs to. Ordinarily, as parties, we would look to raise that in an application, but as I say, the court can also do that of its own volition. Then we come on to striking out statements of case, which is largely set out in 3.4 of the CPR and does overlap to some extent with other provisions, such as the power to award summary judgment or to strike out elements of a claim. So I'm not going to go through that in too much detail, but that can be quite useful, but the court does use it quite sparingly. The big kicker for us, I suppose, is whether we can prevent further litigation because it's already been dealt with under, say, res judicata or the abuse of the court's processes. And a nice kind of element of this came up in Battenburg and Phillips, which was actually dealt with earlier this year. And it's interesting because this claim is entirely on point. The claimant had pursued a claim against the deceased estate. He had already attempted to do so back in 2018 in one set of proceedings in England and Wales and the other in New South Wales in Australia. And the executors are Australian. The outcome of the case in New South Wales was for the claimant to enter into a consent order in which it was very clear he had intended and had agreed to abandon his claims against the estate. So fast forward to 2013, again, the claimant starts to issue and does issue a claim in England and Wales seeking to go over the same issues that he had raised in England and Wales in 2018 and in New South Wales. And the court basically determined that he had clearly already dealt with these issues in the previous proceedings, and there was an overlap between the New South Wales and the first UK claim, and there was no special reasons as to why that should be allowed to continue. If that wasn't enough in this case, there was also issues on service, and it was found that the service of the claim form had not properly happened against the second defendant, and effectively that had been struck out for lapse of service, and there was no extension to that allowed. But essentially the court had found in that present claim that there was an attempt to relitigate claims already dismissed, and there was a cause of action estoppel. There was no or minimal differences between the present claim form and that had been done in previous proceedings. And the court effectively held, if that was not enough, that there was a complete abusive process. And that extended to improper service on either of the second defendant. And therefore, overall, the claim was dismissed. Now, I've got on the other side of the screen some elements or other options to consider in an abusive process situation if you come up with it. At the very bottom, you've got tort of abusive process. It's a very kind of outdated provision, but it is still there, and it dates back from 1838. And then you've got the other standard things to consider, such as unless orders. I think the kind of key thing is when it gets too much is when you end up in the territory of vexatious litigants. And here, again, we're looking at where you've got two or more claims or applications from a party that are entirely without merit. And we'll look first at civil restraining orders. There are three types and they're on the screen. The limited CRO prevents an individual from making any further applications within the specific proceedings without the court's permission. You've got the extended CRO, which prevents an individual from making any applications or issuing claims in the court specified in that order, again, without first obtaining the court's permission. And then you've got the general CRO, which prevents an individual from making any application or issuing any claims in any court without the court's permission. Because they're quite a draconian measure, there are steps that the court will require you to go through. If successful, that will then stop for a limited period. So you've got the criteria: the individual must have made 2 or more claims or applications that have been determined by the court, and it's clear that they have to be totally without merit. In case law, it's come to be found that that means a claim or application must be bound to fail. So the clear thing, and what you should ask the court for if you're looking for something or you anticipate this may be an issue in the future, is to try and seek the wording totally without merit on any applications that come before the court, so that you can then have that basis if you think it may become an issue in the future. The key thing to say about CRAs is that if they are granted, there's usually a time limit imposed on them, and that's usually a maximum of 2 years, which is why we come on to all proceedings orders, which are a lot more serious, because once the CRO is expired, you come back to a situation where the individual can start further claims and applications all over again. So if following the CRO order, the individual continues to make claims or bring applications, it is possible to ask the Attorney General to request that they bring what is known as an all proceedings order. That's set out in section 42 of the Senior Courts Act 1981. You can do it in civil and criminal proceedings, but it is done by the Attorney General rather than by a party to proceedings. If granted, it has the effect of meaning that that individual cannot do anything in criminal or civil proceedings without first obtaining permission from the High Court. And a failure to abide by that can effectively lead to a contempt of court being brought against that individual. Now, something recently that happened in the Attorney General and Millender in 2021 is that the Attorney General obtained an indefinite all proceedings order against Mr. Millender for his repeated applications and claims against Middlesbrough Football Club, which were deemed to have been made totally without merit. Mr. Millender then also sent various threatening emails and other correspondence to the judges, solicitors, counsel for Middlesbrough Football Club. And despite having both an extended and general CRO, he continued to harass essentially those involved. That then led to the Solicitor General bringing contempt proceedings for contempt of court against him. He was found guilty of that and given 15 months in prison in November 22. And there is an entire list of vexatious litigants, which is up on the screen, who have those all proceedings orders and a general CRO against them. So I'll just hand back to Harry to talk about nuisance claims.
Thanks, Sarah. What I find quite interesting before I move on to nuisance is the Pattinson and Winsor case actually involved successfully obtaining an LCRO against the defendant after the trial in the probate, in the Chancery Division, because of the applications he'd made for adjournments and so on. So those were all certified as totally without merit. He had an LCRO put against him. And then when he tried to appeal the outcome of the trial, so not appeal the LCRO, but the trial itself, Mrs. Justice Bacon immediately dismissed that because of the LCRO. So it's a really potent tool. And everything we're saying about social media is absolutely important. The amount of cases I see now with social media screenshots involved in particular is unbelievable, including some completely wacky ones. My favourite that I've ever seen is a Facebook photo of one half of the family plotting to fraudulently obtain probate, with the caption, "Thinking about how to over our greedy relatives." That was obviously a central point in negotiations and at trials. So always be on the lookout for social media issues. But I want to, as Sarah has said, I now want to look at some issues about nuisance claims. There are a couple of angles to this. The first is I want to think about what we as lawyers actually ethically have to abide by and the claims that we need to say no to, even if a client desperately wants us to advance. And in particular, I want to have a think about certain types of claim which have real consequences if they are brought wrongly. And then I sort of want to look at this from the claimant side and also from the defendant side. So what issues claimants need to be aware of in terms of nuisance claims or arguably nuisance claims, and what defendants who receive nuisance claims can do about them. Because I'm sure that everyone in this room has been personally, or this digital room, has been personally victimized by a completely ludicrous claim that has been brought simply to wring clients dry. So first of all, ethical obligations. I don't want to dwell on this in too much detail, but I think we always have to remember that we are all under ethical obligations not to advance cases that are not reasonably arguable. And that is certainly the case with my end of the profession, where my duty to the court means that my paramount duty to the court, I should say, means that I can't stand up on my feet and advance something that I personally think is not reasonably arguable. And that doesn't come up particularly often, but it does come up from time to time, where clients who I understand are desperate and who desperately want a way to vindicate what they think is a wrong done to them will try and come up with some fact pattern or some possible cause of action that they can put to the court, but which on analysis just falls apart. One example of that I've recently had is a real property dispute where my client was trying to argue that a bank seeking possession over his mortgaged property did not have the right to do so because the person who'd taken out the mortgage was in fact his girlfriend. The trouble with that is that my client had witnessed the mortgage deed and in his witness evidence in previous proceedings had averred that he was the one who had procured the mortgage in the first place. So I could not ethically argue or bring a counterclaim against the bank that this charge was not binding on him because every single piece of evidence demonstrated that it did. And we all have to be aware of that. But with that sort of slightly heavier note out of the way, an important note, but a heavier note, I think what we can do now is we can look to some particular considerations for claimants and defendants. So, I'm getting a little bit of feedback there. Anyway, so I think from the... Sorry, I can hear motorbike revving.
I think it's me. And you know, I'm really, I'm in my office. Sorry, everybody. And it's someone doing some work outside of it. So I don't know if Claire needs to mute me. And I'm not sure if she's listening. Because that might get rid of some of the feedback. And I apologise to everybody.
Oh, no, absolutely fine. I will just plough off the dot.
In fact, let me.
There we go. I think that's fixed it. So there we are. So from the claimant's point of view, there are some particular issues that we need to be aware of in terms of bringing particular types of claim in the private client sphere. Now, two of those are claims that I've already mentioned in my previous slide, but are ones that I think are of absolute fundamental importance because of how often they come up. Now, we've all had clients who are convinced that a will that is not in their favour must have been procured by a brother or a sister or a cousin or some other relative unduly influencing the deceased or doing them out of the proceeds of the estate on the basis of lies and calumnies about them. This is perhaps one of the most common first steps that a disappointed non-beneficiary or sometimes beneficiary will argue for in trying to overturn a will. But the cases are absolutely replete with authority saying that bringing a claim in undue influence or fraudulent calumny is not like bringing an ordinary claim. They are both akin to fraud, such that if you bring one unsuccessfully, your client will be punished in costs. And that's a fairly old-fashioned way of saying your client will likely have to pay costs on the indemnity basis. So not to harp on about Pattinson and Winsor yet again, but in that case, the defendant who had brought these two claims, undue influence and fraudulent calumny, was ordered to pay 94% of my client's costs on an indemnity basis assessment. And also had this limited civil restraint order put in against him. So the court was not with him at all, and it reflects the severity of an undue influence and fraudulent calumny claim. A similar case on similar lines was Whittle and Whittle from 2022, where the unsuccessful claim, that was a successful claim in fraudulent calumny rather, but the judge was clear in that case to go over the authorities, emphasising what an abnormal course fraudulent calumny and undue influence are, and what serious claims they are to bring. So from the claimant's point of view, it's important to get advice at an early stage. I would not be doing my job as a barrister if I didn't speak up for the independent bar end of our profession, and said that often where a client is not believing or insisting on bringing a claim like this, notwithstanding the clear and cogent advice given by their solicitors, often the way to break that deadlock is to obtain a second opinion through counsel, who can come in with a sort of fresh eye and repeat, well, if they think best, but often repeat exactly what the solicitor has said to their client. And the number of cases I've had like this are unbelievable, where the solicitor has given practically the same advice that I've given, but hearing it from a second source as well is what is enough to prevent a client improperly bringing a serious allegation such as this. Nowhere is that more important than in cases which are funded by alternative means. So I'm thinking in particular CFA-based cases, but also where after the event insurance is at stake as well. It's vitally important before entering into a CFA, particularly for probate claims, to get good external advice to make sure that the risks are understood, not just by the solicitor, but also by the client. So advice, and particularly objective advice, is something that is essential when contemplating bringing a claim like undue influence or fraudulent calumny. And the claimant can find themselves in real hot water if they bring a claim, hundreds of thousands of pounds of costs have been incurred on either side, and then all of a sudden the losing claimant is ordered to pay indemnity costs. But what about if you're defending these claims? What possibilities are there for dealing with nuisance claims, claims that you've identified as having low prospects of success right from the get-go? Well, first of all, I would suggest that using ADR effectively is an absolute must. So point one is giving out nuisance offers. It may well rankle with clients to give money away, and it is often money, in exchange for a claim that clearly has no legs. But the cost of litigation to trial, particularly now, is so significant that money will be saved simply by making a low offer that reflects and clearly reflects the poor prospects of success on the claimant's part, but which makes everything go away. And I recognise that there is a sort of moral dislike of doing that, a feeling like people are getting away with bringing bad claims, and obviously bad claims. But except in the most clear-cut of cases, except in that sort of 10% at the margins, most claims will have enough litigation risk that it is simply worth paying a little to avoid paying a lot. That can be coupled, of course, with an offer under the Part 36 jurisdiction, because Part 36 enables the offeree to have the risk put on them. I think, Sarah, you have gone quiet again. There we are. So making a nuisance offer is one thing. If you are particularly happy with your prospects of success, making a Part 36 offer is another way that you can add to the pressure as a defendant, adding to the pressure upon the claimant. And if that doesn't work, and if you really are in a situation where the claimant's claim appears to lack merits and appears to be a nuisance claim, there are also, of course, procedures for early termination. So the appropriateness of summary judgment should always be considered. Now, in our areas, a lot of these claims will never be suitable for summary judgment. So claims under the 1975 Act for reasonable financial provision will very, very, very rarely be suitable, largely because a 75 Act claim really is one of degree rather than black and white yes or no. And it's obviously very difficult to summarily determine that, even if the claimant is, an adult claimant with some maintenance from elsewhere. It's very difficult to do that on a summary basis. But on the flip side, if you have a clear probate claim where, let's say, testamentary incapacity is being alleged, but no evidence at all has been put forward, then summary judgment may be appropriate. So that should always be considered. A further point that I just want to flag before moving on is that where you are still before the point of issuing proceedings in a probate claim, and where you've gone through the process of caveat, warning, appearance, don't forget that there is a very below the radar, unknown remedy that is capable of being used in those circumstances, which is to strike out the appearance by a summons to the district probate registry. Now, there is only one reported case on this from the 1970s, and even that doesn't really deal with this in particular detail, but it is discussed in Tristram and Coote on probate practice, and I have personally used this in 2 cases in the past 2 years successfully. And that is under NCPR rules 44, 10 and 13. And what that means is that where an appearance does not disclose a contrary interest in respect of an estate, then it can be struck out for being an abusive process. Now, I don't want to overstate this. If there is a genuine dispute as to whether a will is valid, and the appearance simply says, I would be a beneficiary or an executor under the previous will, then that is never going to be an abusive process. What I'm talking about is where a probate dispute relates to something completely outside the scope of the validity of the will. So, for example, if an adverse party intimates a donatio mortis causa, in that case, that doesn't affect the validity of the will. And so the appearance process, the caveat warning appearance process, is not appropriate for dealing with that. If a person puts in an appearance on that basis, it is absolutely liable to be struck out by the probate registry because it does not indicate a contrary interest. So there's another bit of food for thought. Never forget the NCPR. It's a powerful tool, and it can complement the court proceedings for summary judgment and or strikeout as necessary. So that deals with nuisance claims. And now I just want to finish off with some brief words about criminal remedies. As a general proposition, criminal remedies will not be an appropriate route for most of your usual private client work, but there will be circumstances in which criminal proceedings may need to be brought. The chief one goes hand in hand with what I was talking about earlier, which is where you've managed to obtain a harassment injunction, a breach of it may have criminal as well as civil consequences under Section 2. Also, don't forget that if you have an injunction that is headed with a penal notice, that is enforceable by committal for contempt of court, which is a criminal process that takes place in the civil courts. So that's Part 81 of the Civil Procedure Rules. There are lots of very, very strict requirements for bringing contempt proceedings. For instance, the evidence has to be done by affidavit. There has to be evidence of personal service upon the counterparty. But that is a very potent tool to enforce compliance with an injunction, particularly for harassment, and is indeed what is going to happen in the Pattinson and Winsor case, because sadly it appears that Mr. Winsor may have breached the injunction on a number of occasions. So watch this space for that. Personally, committal applications are difficult. Civil proceedings are not. We become civil lawyers not to put people in prison, but that is what this type of proceeding can do. But it does mean that I, as a barrister, get to wear my wig and gown, which is always fun. So those are a few thoughts about criminal remedies arising out of what I've been talking about. Sarah, I know that there are some criminal remedies available for some of the materials that you've been talking about, like social media. What's the position with those? Sorry, Sarah, we can't hear you. Ah, there we are.
Ah, there we go. Technical
You're back,
difficulty.
Sarah. Yes.
Going back. So So I've left them on screen, but I think because of time, we're just going to have to move on to costs and enforcement very briefly. If there are any questions, or I will share my notes as well in the background. So I'm sorry about my technical difficulties. So costs in general, a whistle-stop tour, general rule on cost investigation apply. Essentially, you've got the starting point is that the loser pays the winner's cost. There are exceptions to the general rule, largely in probate disputes, but we're looking primarily at the court's discretion, which is obviously facts-based, and also the consideration of all circumstances, relevant here being conduct. So the biggest penalty that we'll see, and it's obviously come through in Pattinson and Winsor, in the last few days, it seems to have come through in Ward and Gowling, which has been publicised in all the press, which again, actually, an unsuccessful challenge, A, on capacity, but B, on undue influence. And the biggest award made against someone to show that distaste, I suppose, is the standard versus the indemnity costs that are awarded. So in a typical situation, a standard assessment would be that you would get about 60 to 70% of the cost back. Any kind of issue or doubt would go in favour of the person paying, whereas the indemnity goes the other way. And that means that usually you will get about 90 to 100%. But the kicker in all of this is that essentially you will never get back 100% of your costs. So it's important to consider those other options that there are available. And I've got on the screen that one of the biggest ones, and it was available in Whittle and Whittle, was the use of the unless order. And the reason for that was essentially that it stopped Sonia, the daughter in that case, from actually actively defending her claim, because effectively the CCMC made an order that she had to pay costs by a specified date, and effectively she didn't, so she wasn't allowed to go on. You've got on screen the subsequent proceedings held to be an abusive process. We've got the stay pending payment of costs, which again, that case on screen, Changzi and Mays, was actually where payment wasn't made for costs and they weren't allowed to continue. You've got orders on account of costs, interest on costs, and payment of a cost order as condition for appeal proceedings. If you feel that somebody is actually looking to litigate generally because it's been done by a third party in the background, there is also options for that as well. In terms of enforcement action, when we look at a cost order, a cost order is akin to a money judgment. If you have one where it's made for a payment on account, you can enforce that as you would do with a money judgment almost immediately. If you have to go and get a final cost certificate, you have to go and get that before you can look at the various enforcement actions. Now, I'm not going to cover those now because I'm very conscious of time, but I thought it might be best to leave the floor open to some questions because we've got 5 minutes before the webinar closes down.
Just on, while we wait for questions to come in, just very quickly on cost, don't forget that because they're like a money judgment, 8% interest accrues after the costs order is made automatically under the Judgment Act. So it no longer becomes discretionary by the court. As soon as an award is made, 8% starts accruing, which is a really powerful tool to make people pay up.
So one of the questions, Harry, that we've had come in is, do you think an interim injunction would have been granted for a business or charity if they were the subject of harassment?
The answer is no, and that's because of Section 7 of the Protection from Harassment Act 1997, which states that a person, for the purposes of that act, is an individual and not a company or a corporate body. This was discussed by Mrs. Justice Lang in Merlin Entertainments and Cave as well, where she made very clear that the tort of harassment is not able to affect a company. And I suppose that's intuitive because the actionable thing in harassment is distress or upset. And obviously it's very difficult to see how a legal fiction, which is what a company is or a charity is, can be distressed or upset. So really, I think if you are a corporate and you're being quote unquote harassed, then you may want to see if actually the harassment is towards an individual within that company. But the company itself, I think, will be unlikely to, well, not even unlikely, it will not be possible for a company to bring a harassment claim.
And I think one of the questions we had submitted before the webinar was, how do you keep the emotion out of it? Now, certainly I know I have I'm sure everybody does, people that they do not look forward to opening emails from or getting phone calls from. And that does become obviously a grating part of a day-to-day job. And I think, unfortunately, it's something as professionals that we have got used to, and probably from my experience, it's probably got worse, not better, since the pandemic. Which again goes hand in hand, I think, with people being sat at the end of the phone and emails. It's not the same as being face to face with someone. It's very hard, and I think it's probably just down to you as an individual to manage that. But there are obviously processes you can put in place and to kind of balance that out. But if it's personally against you, and that can become a course of conduct in itself, there are obviously like looks and approaches, again with the harassment point. You don't have to take abuse, you don't have to take be oppressed, you don't have to take aggression. You can take steps to kind of bubble yourself up from that and protect you.
Agreed. And don't forget, if it's coming from other members of the profession, which I'd hope it isn't, but sometimes, you know, sorts of things happen, the professional regulators take a very dim view of that conduct.
And there's no other questions, so it's just, I don't know if there's any closing thoughts from you, Harry.
None really. It's a really interesting area, and I think as disputes start becoming more digitized and more recorded, these sorts of claims will start to grow in popularity. You know, 40 years ago, for example, all of this stuff would have happened by people talking to each other, and it would have been all dealt with in witness evidence and so on. But with everything, with human communication being more published than ever, we've got to know as private client lawyers about publication rules, about media law, about ways of preventing and protecting clients. And it's a brave new world, but it's an important one to know about.
And from me, I think thank you to Harry, thank you to Claire behind the scenes for setting us up in terms of the webinar at the Bristol Law Society. If there are any questions, we will circulate our contact information. Feel free to come to us directly. We are, like I say, going to have more private client webinars throughout the year. So if anyone would like to do any or have any topics they particularly have of interest that would touch their kind of issues day to day, feel free to give me a shout. Other than that, it's just to say thank you for attending. And as I say, thank you for listening to us.
Thanks very much indeed.